All right, well, it's time to get started. First and foremost, hello, Texas. We are officially done with the legislative session, Sine Die, or Sine Die, as the Latin experts say. That occurred last Monday. So last Monday was the last day for the legislative session, which means all the bills that could be passed by the House and Senate have been passed by the House and Senate. The governor has got a smattering of bills on his desk. He has until the 22nd to do one of three things. So, first things first, we're going to talk about bills today that have already been passed. But we're also going to talk about bills that are currently on the governor's desk. And so he can do one of three things. He can sign the bill and it becomes law subject to whatever the effective date is in the bill. He can do nothing. And if he does nothing, it becomes law after June 22nd. Or he can veto the bill. If he vetoes it, it goes back to the House and or Senate for some sort of a supermajority vote if they so choose. That's very rare. But before we get into all that, first and foremost, hey, good seeing y'all. Or, well, not seeing y'all. Hopefully y'all can see me. My name's Clint Brown. I am an equity shareholder with Roberts, Markell, Weinberg, Butler, Haley. Again, attorneys love their names. I am board certified in Property Owners Association law as well as residential real estate. So double board certified. That means I am a POA nerd. I'm also a member of the Texas Legislative Action Committee. That stands for TLAC. It's a lobby group that fights for community associations' rights across the state of Texas. I had the pleasure of speaking in multiple House or Senate hearings this session, speaking with legislators, talking about the concerns that we've got or the support that we have for various bills that we are going to be talking about today. Do we have any chickens? Any chicken bills that passed this year? I don't know. Let's take a look. And then finally, if y'all have questions, please type them in. Mr. Beam, Kyle Beam, one of our head marketing gurus at our firm, is kind of going to be taking note of those, and we'll go over them at the end of the presentation. It's 11:34 now. My goal is to give us about 10 to 15 minutes to go over those questions. So please sit tight. First, actually, not first. Second, attorneys love their disclaimers, so got to give it. The information presented today is based on the law as it exists today, June 10th, 2025, and it's presented for educational purposes, does not constitute legal advice. If you need that legal advice, please reach out to your association's counsel. With all of that said, I know we get some hypotheticals, and that is okay. Just remember, it's not legal advice, educational purposes only, and you get what you pay for. All right, let's go ahead and go through everything. So our agenda, we're going to go over legislative session by the numbers, and then we're going to get into the session bills that are soon to become law or already are law. Okay, by the numbers, we had approximately 63 POA-related bills. Let me press pause and give a definition because I'm going to be using these terms interchangeably today. A POA is an acronym that stands for Property Owners Associations. It covers single-family communities as well as condominiums. So when I use the word POA, that covers single-family communities as well as condominiums. HOA, that is a term of art used to only refer to single-family communities. So when I use the word HOA or Chapter 209 community, I am referring to single-family communities only. Term of art number 3, condominium association. Y'all probably know that, but that is different from single-family communities. A condo association is where the owners own in common the common elements based upon a certain percentage. They don't own the actual dirt. It is owned in common by the owners. There's other requirements to be a condominium. But those are the three terms of art I'm going to be using today as we go through each bill. So again, 63 POA related bills considered in the 89th Texas legislative session. Please know there were over 100 in some way, shape, or form dealing with POAs, but 63 are the bills we really honed in on. 7 bills directly related to POAs passed in the 89th Texas legislative session. So we are going to be going over those 7 bills that are law or are soon to become law. So again, there are a couple that are on the governor's desk. And then finally, condominiums, $375. That is your cap for resale certificates, now capped at $375. We'll talk about that bill as well. And then finally, sorry, I'm sure y'all were on the edge of your seats holding your breath. 0 chicken bills passed this legislative session. I think that's important to point out because I have gotten a total of probably 20 phone calls and emails from various managers that have said, "Hey, Clint, I heard that there's a new chicken law. Hey, Clint, I heard that if municipalities allow for chickens, the HOA has to allow it as well." So let's clear the air here. No chicken bills passed. There are some chicken bills that passed one house or the other, but none of them passed both houses and made it to the governor. So what does that mean? That means if your deed restrictions, your declaration, your CC&R say no chickens, then you cannot have chickens in the community, subject to certain state and federal rights. So again, general rule of thumb, more restrictive covenant controls. As no chicken is more restrictive than any county or city ordinance, the deed restriction will control. So if your declaration says no chickens, no chickens. Bok bok. All right. Bills that have become law. Let's hit these first. First up, House Bill 431. It is a procedural bill that essentially adds solar roof tile to the definition of solar energy device. This applies to both HOAs and condominiums, so single family and condos. It only applies to condos whose owners have the responsibility to maintain their own roof. So if you are a condominium where you maintain the roof, you don't have to allow a solar energy device on the roof. I want to make that clear. But for those condominiums where the owner has to maintain the roof, the owner does have certain solar energy rights. So this really just adds solar roof tiles as another solar energy device. Prior to this law change, we were dealing with solar panels as shown in the picture here. Those are solar panels. Solar roof tiles, I know that Elon Musk and Tesla developed a solar roof tile, and that's what this bill mainly addresses. It allows for those, and there may be some other manufacturers out there, but that's it. So nothing too exciting there. In terms of an action item, you may have to update your solar energy device policy. So get with your counsel. He, she, or they should be able to give you some direction there. That's number 1. That was quick. Next one, House Bill 517. This is a very big bill for those Central Texas communities that I know Houston doesn't really know this term of art. Watering restrictions, right? So a watering restriction can be issued by a county and or city where the owner is restricted to a certain watering schedule. You can only hand water. You can only use an irrigation system certain days of the week, depending on whether you're an odd numbered or even numbered street address. Various levels, various stages for watering restrictions. This bill adds another section to Chapter 202 of the Texas Property Code. It applies to both single-family communities and condominium associations where the owner is required to maintain their landscaping. So HOAs and condominiums. For condominiums, it only applies to instances where the owner has to maintain their own landscaping. It prevents an association from levying a fine for discolored vegetation or turf, i.e. grass, when there is a watering restriction in place and for a period of 60 days thereafter. Once the watering restriction is lifted, you have to wait 60 days to start levying fines. So what does this mean? This means if you're in a community association in Texas, you've got your management company doing their drive-bys, right, looking at all the violations. The management company can send a violation letter to an owner with discolored vegetation or turf, but cannot levy a fine. So you can still send enforcement letters, but you cannot levy a fine for discolored vegetation or turf when you are in a residential watering restriction issued by a municipality, a water utility, or a retail water supplier. So, action item, you have to update your fine policy to add this rule. It is extremely important for those communities in Central Texas to do this and West Texas to do this, because I think I'm out in Central Texas and I've been under a watering restriction for maybe the past 4 years. So it's very important to update that fine policy. Number one, management companies, it is very important to update your internal procedures so you do not send fine letters for discolored vegetation or turf. And likely the management company's violation letter is failure to maintain your property, your landscaping, right? Failure to maintain your landscaping is the general catch-all that management companies use for violations. Well, you can still send the letter, you cannot threaten to levy a fine. So on the books, it's not a complicated rule, but procedurally, it's going to be a little bit difficult. So make sure managers, y'all get with your management team to come up with a game plan. And please, please, please update that fine policy so that we are compliant with state law. Get with your legal counsel. They can help. It's going to be a very simple amendment. Okay, next one, Senate Bill 711. This is actually big picture, very good bill. It's got some restrictions in there, but big picture, it really does help community associations a lot. This bill passed both the House and the Senate in 2023, but it was vetoed by Governor Abbott due to reasons unrelated to the bill. So it had nothing to do with the bill. It's a bit of some political issues between certain parties, and Governor Abbott vetoed our bill. So it got reintroduced at the 2025 legislative session, got passed by the House and by the Senate, got put on the governor's desk, and the governor signed it. So it is law that is going to be effective September 1st of 2025. There is a March caveat I'll go into, but let's get into it. Number one, as it relates to condominiums, you must now, so if I think 60 is the number, if you've got 60 or more units in a condominium, you must have a publicly accessible website. So you must have a website now, number one. Number two, you must update your management certificate. So the condo management certificate now has additional requirements in it. One of those requirements is to include your fee schedule in the condo management certificate. There are some other requirements, but once you get your management certificate updated, condominiums, and filed in the real property records, you must then file the management certificate with TREC. TREC stands for the Texas Real Estate Commission. TREC, Texas Real Estate Commission. Look, it is what it is. We already have a county filing requirement, so it's already open to the public. But this is one of those things that we had to do to get some other good things in the law and some fixes done. And look, single family communities, HOAs already have to file their management certificates with TREC. So what this does in a nutshell is it almost mirrors word for word what an HOA has to do. So it took the HOA law and applied it to condominiums for management certificates. So what is the action item here? The action item is you must update your management certificate if you are a condominium or you represent condominiums. You've got to get that management certificate updated. Once it's updated, you also have to file with TREC. Management companies, y'all have to adjust your internal fee schedule so that you're compliant with the 375 cap. So that's item number one. Item number two, this is a win. This is a good thing. It applies to pretty much HOAs. There may be some limited condominium application, but not really. This is pretty much an HOA law change. It relates to perimeter fencing. So back in 2021, there was a law that was passed that gave an owner an absolute right to install a fence surrounding their entire lot, surrounding the perimeter of their lot. And a lot of associations and their council, and we've got case law on this, ran into this issue. What happens when the lot includes an easement? Maybe it's a drainage easement. Maybe it is a sidewalk easement. So there's literally a lot of communities in Texas, you'll have your lot and then you'll have a sidewalk run through an owner's lot. And that's an easement allowing other people to use the sidewalk. Well, we ran into this issue with an owner has the right to enclose their lot under state law. Well, now you are infringing on other owners' rights to use the sidewalk. Or what happens if the fencing devastates the drainage pattern, right? Messes the drainage pattern up. What if they're wanting to use solid slatted boards and now the water can't drain through the drainage easement properly? So lots of issues we were concerned about. And then finally, it could change the aesthetic of the community, right? Significantly. You drive down a street in a lot of master plan communities, you don't see front yard fencing. The fencing just goes up to the frontmost portion of the build line, right? Of the residential structure. And you don't see that front yard fencing. Well, now if every fifth home has a fence surrounding the entire perimeter of their property and it's 10 feet tall, that can affect the fair market value of the community and the aesthetics. So all these issues were raised. We were able to work with the legislators, work with the realtor lobby group, and we came up with a compromise that allows for us to address certain perimeter fencing issues. So now we can restrict fencing over easements, require fencing to be set back a certain amount of distance when there's a driveway entrance and a gate, so that you're not having people stuck on a public road or private road trying to get into their property and holding up traffic. Finally, one of the big ones we were able to get is where your deed restrictions say no front yard fencing, we can restrict front yard fencing now. So you can actually restrict fencing so that it doesn't get to be around the perimeter. There are certain exceptions to that rule, but that is our general rule, and it really is a big win. So the action item on that, this really applies to HOAs. You have to update your security measures policy. Update your security measures policy for HOAs. Next one, ACC membership. This is just HOAs. It's not condos, just single family communities. And again, in 2021, there was a bill that was passed that essentially said you cannot serve on your ACC. ACC stands for Architectural Control Committee. There may be different terms of art. ADRC, I've seen, Architectural Design Review Committee, ARC, Architectural Review Committee, but I'm basically I'm going to call it ACC. So you cannot serve on your ACC currently if you are a board member, if you are the spouse of a board member, or you reside under the same roof as a board member. It didn't apply to communities during the developer period, but these were the restrictions to serve on the ACC. You couldn't be a board member, couldn't be a spouse, couldn't reside under the same roof as a board member. And this affected communities big time. They couldn't find any volunteers, right? This is a bit of a thankless job a lot of times, right? Not many of the 3 H's, hugs, high fives, or handshakes. It's tough, and hats off to y'all as volunteers, those of you that are on the call. It's a really hard job, and it can be thankless. And with that in mind, these boards, these communities were having problems finding ACC members. And so they would actually have to pay third parties or management companies to offer that service. Well, this law helps in that it says this: hey, look, if you can't get somebody to serve on the ACC, send out a solicitation of candidates notice, and it's for the ACC, not for the board, for the ACC. And after that time elapses, if nobody throws their name in the hat to be on the ACC, the board or a spouse of a board member or somebody under the same roof as a board member can serve on the ACC. So again, very, very important bill, and it helps to alleviate those problems for boards and ACC members. There's a whole process you've got to follow. So action item for this one, you have to adopt an ACC solicitation policy, because it's going to detail the steps to take so that the board can be the ACC. And it's not an overly complicated process. If you've got a management company, they'll be able to help. If you're self-managed, get with your counsel. He, she, or they can kind of help guide you through it. So again, summary: actions to take for condominiums: creating the website, updating your management certificate, filing the management certificate with TREC, and then ensuring your resale certificate fee is capped at $375. On this, if you fail to comply, and you've got until March 6th of 2026 to do this, so there's some wiggle room if you are already formed. Most everybody on the call, their condominium's already been formed. So you've got until March of next year to get this done, which is good. But if you don't get it done, the penalty is, if you've got a delinquent owner, that owner doesn't have to pay for attorney's fees and certain other costs during the period of noncompliance. So it is very important to get with your community association council to get that management certificate updated and compliant with this new law. It becomes effective September 1st of 25, but you've got some wiggle room if you're already formed to get it done. Okay, so that's condominium. Single family, you've got to revise your security measures policy for fencing. You've got to do that notice of solicitation for ACC members policy. And then if you've got a 209 hearing policy, you need to tweak that to remove any ACC prohibitions. So again, get with your counsel. He, she, or they are going to be able to help. Okay, that was a big one. Next one is Senate Bill 2411. This thing is massive. I will say that it's a very long read, and very little of it applies to single family communities and condominiums. It does apply to both. And it amends Chapter 22 of the Texas Business Organizations Code. Chapter 22 of the TBOC. That chapter deals with nonprofit corporations. And almost all community associations fit under the nonprofit corporation umbrella. So y'all are subject to Chapter 22. This one focuses on basically ratification. It also talks about committee rights. Again, nothing too exciting. Ratification. What is ratification? So this is a way when a community association board makes a misstep and does something procedurally wrong, which an owner could challenge on procedural grounds to render the action void, voidable, ineffective. Basically, hey, board, you voted on this wrong and it is not enforceable. Well, you may be able to use Chapter 22 to ratify the action, and you get with your counsel, you follow some legal steps, and once it's statutorily ratified, nobody can complain about it anymore. So it's a way to protect the community when maybe the board makes a bit of a procedural misstep. Nothing too exciting on the changes. It gives your council a little more wiggle room to fix some problems when there is a procedural defect in an action the board took, or maybe the owners took. It is available to member action as well. So again, really kind of legal jargon, mumbo jumbo. Just know that statutory ratification is there, and it's very important to get with your council to effect a statutory ratification if it is indeed needed. No actions to take here. All right, 1 out of 7. No actions needed. Let's keep on cruising. Next one. So we're going into Senate bills. This is Senate Bill 2629. This applies to single family communities, so HOAs, as well as condominiums, and it makes it crystal clear for communities that you can have electronic meetings, you can have telephonic meetings, and you can have electronic voting in certain instances as well. So this helps to solidify the idea that electronic voting is okay, is here to stay. It is very helpful for condominiums, in my opinion, because there was a statute that created a little bit of heartburn for attorneys on electronic voting. This helps in that regard. It doesn't help 209 communities or HOAs quite as much, single family, but it is still helpful. So it provides some clarification for electronic meetings and electronic voting. Actions to take, likely none. But you may want to adopt a voting policy, a voting procedures policy to help your management company team members and the board to do it right. We don't want to do it wrong, and sometimes that can really be helpful to have a kind of a meeting policy to make it crystal clear how to conduct board meetings and how to conduct member meetings. A member meeting is another term of art that y'all are probably familiar with. Annual meetings. That is a meeting of the owners. Most of the time, those are the only member meetings boards and community associations have. Okay, so let's pause there. Those are the bills that are law. That are law today. No ifs, ands, or buts about it. No wiggle room. It's done. The next bills we're going to be hitting on are in front of the governor, right? So they're on his desk right now. They have not been necessarily approved by the governor. I didn't get a chance to look this morning on status, but as of last week, they had not been signed. So maybe the governor signed them over the past 2 days, maybe not. So I'll go back to what I talked about earlier at the beginning of our call. One of three things can happen to these 2 bills. 2 out of the 3, it becomes law, right? So number 1, the governor can sign the bill, it becomes law. Number 2, the governor can do nothing, and on June 23rd, it becomes law. Number 3, the governor can veto the bill, in which case it gets sent back to the House and or Senate and likely does not become law. So if we can get one of these 2 out of the 3, we're in good shape. Is good shape the right term? Well, let's look at these bills and see whether or not that's the case. House Bill 621. This could be viewed as a good bill. It may help community associations, and it relates to political candidates for an upcoming election and or government officials, and it's their ability to go into a community association and speak to the community association members, residents, and invitees of the members and residents. Is that a good thing or a bad thing? So prior legal advice is, hey, board asks, hey, Clint, can we have a political campaign rally here in the common area? My typical response was, no, I don't recommend that because, we've got 2 parties, right? We've got Republican and Democrat. If the board is seen as supporting Republican Party and or Democrat Party, it can get you in trouble with the other side. And so let's avoid those. Well, look, state law says now if an owner or resident requests a a kind of a political rally or political meeting for a candidate or an existing government official on POA common area, we have to allow it. We have to allow it. So this applies to single family and condominiums, and you've got to allow it. Now, here's the good thing. Here's what we were able to work with the representative on, Representative Patterson on. They get treated like any other request. So if this coming weekend I make an application for a rally for an upcoming election, and Bill has already reserved that common area for a birthday party, Bill takes precedent, right? Sorry, Clint, Bill's party's already booked. This weekend is not available. And I have to live with it. I have to get in line just like everybody else. So it gets treated just like any other common area reservation, which includes the obligation to pay a rental fee or deposit, maximum occupancy limits you can establishing hours, common area available for the meeting, and then finally requiring some sort of written reservation or rental agreement. So again, and there are some other limitations we can impose. Actions to take, y'all really, really should revise, if you've got one, or implement a common area usage agreement or policy. I think it's important to have this in place because boards may get it wrong. And we want to show the community that we are being consistent. We are not showing favoritism to one party or candidate or the other. We are allowing an owner or resident to simply reserve our space, reserve the common area. So please get with your council. He, she, or they should be able to help craft or amend an existing common area use policy. So again, this one's on the desk. I should have looked this morning. I didn't. I don't think it has become law yet, though. Next one. Oh, look at that. Cute little deer. It's all about baby deers in the wild. No, it's House Bill 2842. It relates to actually regulating deer species, white-tailed deer population more specifically, when recreational hunting is not feasible for controlling the population. This, maybe we've got some East Texas communities, but we see a lot of deer in Central Texas, West Texas, and sometimes they can become a nuisance. Look, deer, big time vector for spreading Lyme disease and other diseases. They're cute, adorable, but sometimes you need a humane way to regulate deer populations. And this law allows for a community association to work with an expert to come up with a plan to submit to the state, the Parks and Wildlife, for them to review and approve. So it allows for community associations that have significant white-tailed deer population issues to come up with some sort of a mitigation plan to try to reduce those deer numbers. So again, if you're one of those communities that really, really has a big issue, just destroying landscaping, destroying homes, this bill provides for some processes. I don't think look, if deer is a big problem, get with your council. He, she, or they are going to help to kind of get an expert retained, get with the appropriate Texas department to get your plan reviewed and approved. So if you've got a problem, get with your council. This isn't some policy you've got to adopt statewide. It really is kind of case by case. I'm going to go over these fairly quickly. We've got probably another 7 minutes, so we'll go over this. Bok bok, here's a chicken bill, House Bill 294. It passed the House on May 2nd, referred to the Senate Local Government Committee on May 5th, where it died. So it died in committee on the Senate side, so it passed one House. This would have allowed for the growing of fruits and veggies most places on the property, including the front yard. And then the raising or keeping of 6 or fewer domestic fowl, 6 or fewer adult rabbits. So rabbits and fowl. Fowl's an interesting term because that doesn't include that includes more than chickens, right? Maybe it includes turkeys. Maybe it includes dove. What is a fowl? What is a bird? You'd have to look at some statutory definitions, but it definitely encompasses more than just chickens. Didn't make it anywhere, passed the House, but died in the Senate. Here's another chicken bill, House Bill 2013. This one had a lot of legs. Bok bok, nerd attorney joke. It passed the House, Senate, left pending in committee on May 19th. So it got referred to the Senate, left pending on May 19th. It had a lot of movement because it was a little more conservative. And it said in a nutshell, hey, if the city where the community is located allows for chickens, then you have to follow the city code, whatever that code may be. That's what the bill said in essence. It would have applied to single family communities, so HOAs, and condominiums whose owners regulate their yard space. So it could have impacted condominiums as well. The issue is we've got some city ordinances that allow for a lot of chickens. I think city of Houston, something like 22, 21. It's a lot of chickens for a quarter-acre parcel. So again, if you like chickens, if you don't, this one came close. Will we see chickens next session? Absolutely, 100%. I think I've seen them every single session since 2011. So they're going to come back. Will they ever make law? Who knows? But these did die at the Senate, left pending in committee for both of them. Senate Bill 2586, House Bill 44474. For those of you that know that commercial. Senate Bill 2586, House Bill 4447, Flores and Hickland. This dealt with basically a requirement that all dedicatories be filed with TREC, Texas Real Estate Commission. And if you didn't, you wouldn't be able to collect assessments, fines, or fees during the period of noncompliance. This was a really big bill that was concerning to us and to me personally, because look, I've got some master plan communities that were built in the 80s, and maybe they've got 105 documents that have been recorded, and maybe we've only been able to locate 103 of them. So this law said if you failed to file with TREC 2 out of the 105, you wouldn't be able to levy assessments, collect fines or fees, because you're missing 2 out of the 105 documents. And that's really scary. Title companies are not infallible. They miss documents all the time. And so it was a very scary bill. One of them, so Senate Bill 2586 passed the Senate, and it was referred to the House where it died in committee. So we definitely had concerns on it. It only affected single family, but it didn't make it anywhere. House Bill 336, Senate Bill 690, this related to local law enforcement and their ability to contract directly with community associations. I won't get into details on it because it didn't become law, but it was just something giving a little bit more freedom to local law enforcement to contract. House Bill 1862, Senate Bill 2679, similar to law enforcement services. Finally, House Bill 1087. This was a unique one in that if there was any vacancy on the board, you had to have a special election, a special meeting of the owners where that vacant seat was elected. The concerns with that is, of course, what if you have nobody willing to serve and run, number one? And then number two, the cost, right? It's another annual meeting or another member meeting you've got to have. That results in cost. Maybe it's de minimis for smaller communities, but it can be very expensive for larger communities. So those were the concerns there. Again, it didn't make it out but it was a little worrisome. Final slide here. Is it too early for preview of the 90th legislative session? Chickens, are we going to see them? Absolutely. I mean, if I was a betting man, I think we will definitely see a chicken bill. We will see further attempts for government regulation, and then, maybe we'll see some new issues we haven't seen before. I think it's important for community associations to remember reasonableness and consistency are key. Reasonable and consistent. You've got to be reasonable in your levy of assessments and your enforcement, and you have to be consistent in your enforcement. That's how we reduce the number of bills. Keep in mind that all it takes is one representative or Senate constituent to complain to create a bill. That's it takes. That's it. So please be reasonable, be consistent. That is going to help keep things a little quieter. I'll say there was a comment made, I think it may have been from the House floor, that an interim study on community associations may be needed. Interim studies occur between legislative sessions. That means there may be some hearings and a study conducted in 2026. It's usually the summertime. So keep that in mind. Be reasonable. Be consistent. That is going to help avoid bad legislation. Because again, legislators are reacting to concerns of their constituents. And although their intent and their desires may be good, it can lead to some unintended consequences. With that, let's get into questions. I'm going to do a stop share here. Get into questions and see.
Hey, Clint, while you're looking at those, I have a question for you.
Yes, sir.
Will there be a special session this time after we saw so many the last time?
Man, that's a good question, Kyle. I hope not. I think the governor got a lot of what he wanted to get done with the school voucher. So I don't think there'll be a special session, but who knows? Who knows? Let's go ahead and get going. Let's go got some presenting. Sorry, let's see here. Oh, a copy of the presentation will be provided, a link to the video and all attendees. So you will see something here soon. And there will be, so our law firm will provide an action item update to everybody, along with kind of action items and rough costs, all that good stuff. So y'all will see an action item list on what you need to do here in the coming weeks. And okay, first question. If the association wants to amend the docs to allow chickens and they are not within city limits, can they allow? Absolutely. And that's what we're all about, is if a community really wants to allow chickens, amend your declaration and allow for chickens. If that's what the community wants, that's okay. I actually just did one for the community within the city of Austin last year, and it passed. It was a community of about 400 homes, and they wanted chickens. They amended the declaration, and it passed. Oh, this is a good one. Is dirt still finable, or is dirt considered brown grass? A couple chuckles. Look, very good point, and a good argument and concern. I mean, is that considered discolored vegetation, or has it gotten so bad that there is no vegetation? It's kind of case by case. So get with your counsel so that you can make an informed decision. But on dirt, right? No grass, no turf. I think you could make an argument that that is finable because there is literally nothing to maintain. It is the fact that you don't have anything there that is the concern. So that could be finable. But again, if it's just this much dirt and this much brown, I don't think you can fine. So case by case, very good question. Let's keep going here. Let's see here. Next one. Can fines be assessed if there is no lawn? Oh, we've already addressed that one. What if hand watering is allowed but irrigation is not? If you are under a residential watering restriction, which it sounds like you are, no fining for discolored vegetation or turf. Yeah, any level of restrictions. Sorry, it is any residential watering restriction. If the trees or vegetation have died, can we request that they replace them? Yes. So I want to make it clear, this just means you cannot fine. You can still enforce your deed restrictions, i.e. require them to replace their vegetation or tree or landscaping with something more drought tolerant. Can we move forward with a forced resolution? Yeah, potentially. There's always risks associated with replacing one tree with another tree. I don't know that we want to go down that road, but there are some forced, some self-help remedies that y'all could implement. Next question, does this mean if the assessment changes that we need to refile the management certificate? So you don't have to include assessment amounts because those aren't related to the sale of a home. Yes, you collect them at closing, but we take the position that that's a recurring charge. It doesn't trigger upon a sale. So we're talking about fees that trigger upon a sale. Very good question for resale certificates. Next question. Can the management company block access to their website portal to owners who are delinquent? I would say I don't know that you can. That's a good legal question. It may be governing document dependent though. So very, very good question. I would maybe pitch that one to your council or your management team. Do HOA agendas need to be publicly accessible? No, I don't think so. That's not a book and record yet. Now, when association meeting minutes become official, should you post them on your website? I think that's a good idea. Okay, so the website must be publicly accessible. Yes. What about a community that restricts fencing to 350 feet total, but only allow for that's an interesting question. So the question is, what about a community that restricts fencing to 350 feet total? They have 1 acre plus lots, but only allow for a yard area to be fenced. I think they're gonna, if push comes to shove, they're gonna be able to surround a certain part of their perimeter. So there is a little bit of wiggle room there. You'd have to get with your council to see if there are any easement rights that can allow us to kind of restrict the fencing a little bit more. So good question, but it is a legal counsel question because it's largely governing document dependent. So for that question, please get with your counsel. Oh, I'm sorry. Looks like we were frozen there for a little bit and then it got accelerated. Sorry about that. What if a board already had a spouse or board member on the ACC committee before this passed? Well, that original restriction passed in 2021, so that may be an oopsie. Get with your counsel on how to fix that. How much time is needed for solicitation? I think it's 10 days. I usually recommend 14. Recap email, yes, you'll get a recap email. Yeah, so again, kind of reiterating the fact that as of 2021, if you were a spouse of a board member, you could not be on the ACC. That's a 2021 law. The new law allows for the spouse to be on the ACC only if you try to solicit ACC candidates and fail to solicit. So again, we've got 3 ACC positions open. You send out a solicitation. You have 2 out of the 3. You have 2 people throw their name in the hat. That means those 2 people get to be on the ACC. The third spot, you could have the spouse of the board member or a board member or somebody residing under a board member's residence, right? So that's how it works. You've got to solicit first. How often do you have to solicit? Kind of governing document dependent, so get with your counsel on that one. Deadline for solicitation is 10 days. I like 2 weeks. It's a little bit easier to manage. Board member meetings. Okay, so for board member meetings, are text messages defined as part of electronic communication meetings, or does electronic meetings only via email? I do not recommend text message actions outside of a meeting. I only recommend email, and that's for record keeping. Emails are the way to go. Text messages, I do not recommend. There's a multitude of reasons why. I can give you real world examples why it's a bad idea. If you're still concerned, reach out to your counsel. He, she, or they should be able to give you some, give you a legal opinion on that. If our only common area is our actual pool, do we have to allow meetings in our pool area? Do we have to allow people outside our HOA to attend our common pool property? So if the common area, if y'all allow for people to reserve the pool for parties, et cetera, you may have to allow for a rally subject to occupancy limitations. So that is a maybe on that common area reservation for political rallies or candidates. Next question. What if we do not allow reservations currently for any common area space? Do we need to create a new policy to allow this? You may be able to continue not allowing reservations. That may be something you can do. But then my follow-up question is, well, do owners regularly group together and utilize certain common area space for group gatherings? If the answer is yes, well, then if somebody has a political gathering, you wouldn't be able to restrict that. So it may be a good idea to have a common area use policy so you can ensure you're being consistent in the use thereof. So it just depends. Good question, but you may have to reach out to your counsel to get a little bit more in depth on that one. How big is the common area? How often is it used? Are we talking about a 10 by 10 piece of grass? Next question. For political events, it's got to be an owner or resident requesting use. Owner or resident requesting use of the common area. We have issues with beavers. LOL. No beaver bill out there, just white-tailed deer. If only it pertained to squirrels too. Y'all are throwing some zingers out there today. Fred and Wilma, emu, geese. So again, just white-tailed deer. Landscape areas we've addressed. Again, if you've got owners, basically getting into landscape areas, I think it may be a good idea to get a common area policy. But look, if it's a non-issue, nobody ever uses the common area, then sit tight and let it play out. You may not have to adopt a policy in that instance. Let's see, almost done. Can we get oh, yes. So the presentation will be shared. Oh, next question, House Bill 2025 for recording plat maps. And then Senate Bill 17 regarding property ownership for certain foreign persons and entities. Nothing really to worry about there. There's nothing y'all need to adopt. That's more developer driven. And the recording plat map was actually something benefiting community development. So y'all should be good there. Senate Bill 17, that may be something good for management companies to think about on what entities or persons are allowed to purchase versus not. And the question is that something we have to regulate, or is that something the government should regulate and not a community association just involved in giving a resale certificate, right? So Senate Bill 17, we may not have anything to worry about. Portal accessible to owners only, but is accessible through the internet. Is that publicly accessible? Potentially, that could work. Again, get with your counsel and or management team. Your management team may be able to answer that question for you. But if not, get with your counsel. He, she, or they are going to help guide you to ensure compliance with that new law. Oh, okay. Our condo bylaws state that if a bylaw, rule, or fine is changed, it does not have to be filed with the county to become effective. Is that still true? No, that is not true. And that has not been the law for quite some time. So 202.006 says that in order for a rule to be effective, it must be recorded in the real property records. So if you change your rule, in order to enforce it, you must have it recorded. So to the extent you don't have your bylaws or rules or fines recorded, please work with your council to get that fixed, because 202.006 of the Texas Property Code creates a problem for you that applies to both condominiums and HOAs. Oh, and somebody answered the question that I just answered. Thank you. If an HOA in Bexar County wants to contract with the sheriff or constable, are we allowed to? Yes, you are. Continue your contract. What is the definition of watering restriction? So again, level 1, that's a watering restriction. Got to comply. Can fines be assessed if there is no fine policy in place? No, you cannot levy fines without a fine policy, especially if you're an HOA. 209.0061 of the Texas Property Code says you must have a fine policy. So if you don't have one, please, please, please get with your management team and your council to get one drafted, adopted, and recorded as soon as possible. Do you have to refile a management certificate after you adopt a new policy, say the ACC solicitation policy? No, you do not. That's good. The management certificate only requires that you reference the declaration and any amendments thereto. As a policy is not a declaration, you do not have to list it in the management certificate. So good news there. Costs, that does certificates of compliance. If resale certificates are capped at $375, how would this affect costs for an HOA that also does COCs? I believe that stands for a certificate of compliance, basically a drive-by to see if the home for sale has any violations. I don't believe it would affect your ability to charge for that. So you should be okay. Again, get with your management team that levies those, and you may have to pull in your counsel for a formal legal opinion. House Bill 6, we've answered that question. Their law, boy, so I'm going to try to hit some of the big ones because we're running out of time. A lot of these I've kind of answered. Oh, chronic wasting disease. Good point, Mr. Young. It's kind of like zombie deer, yeah, for whitetail. So again, if you are changing rules or regulations that you're seeking to enforce, every time you change that rule or regulation, you must record that change in the real property records to be enforceable. So remember that, and it's 202.006 of the Texas Property Code. With that, we are done. So again, we've got a couple bills that are still with the governor, but that's what we're looking for coming up for this session. Thank you all so much for joining me today. I always appreciate y'all having me and listening to an attorney talk on and on. I hope it wasn't too boring. And Mr. Beam will be sending out a copy of this presentation in the coming week or so. And we will also be providing an action item so that y'all can remember what we talked about today. So, hey, thank y'all so much again. You enjoy the rest of your day and enjoy the rest of your summer. Bye, everybody.